Good afternoon. This is the Law Guide tutorial. Today, we'll be discussing mistake under the law of contract. Mistake is one of the vitiating factors under the law of contract. So we'll be looking at the effect of mistake at common law and in equity, the types of mistake, presumptions under each type, and also consider whether or not the presumption can be rebutted. Then, before we conclude, we will recap and finally pose a question. Mistake is one of the vitiating factors under the law of contract. What then are the vitiating factors under the law of contract? Vitiating factors relate to factors which could negate the apparent consent of one or both parties to a contract and thus render an apparent contract unenforceable in some respect. In effect, vitiating factors are legally recognized factors which make an apparent contract lose its validity when it comes to its enforcement. The vitiating factors recognized by the law are mistake, misrepresentation, duress, and undue influence, unconscionability, and illegality. What does mistake mean under the law of contract? Meaning of the word mistake has a more restricted meaning in law than in popular speech. In popular speech, it could simply mean an error, and so not every mistake will do, but a legal mistake capable of nullifying apparent consent of a party or parties to a contract. So in contract, to be mistaken is to be wrong as to a matter of fact that influences the formation or the making of a contract. Now, what then are the effects of mistake in contract? We will discuss this in two dimensions, from the common law perspective and from the perspective of equity. At common law, mistake renders apparent contract void ab initio. Under equity, if it's a case that can be dealt with not at common law but in equity, the court in exercise of their equitable jurisdiction to grant a decree in persona may grant specific relief against the consequences of mistakes without declaring the contract a nullity. So in equity, mistake operates in the following ways. Mistake may be a defense in an action for specific performance. So one may refuse specific performance and set the mistake up as his defense. Mistake may also entitle the parties to have a written contract rectified. So where a mistake is alleged, it may entitle the parties to rectify that written contract to reflect their actual intentions. Thirdly, mistake may also be a ground for the rescission of a contract. Now, what are the types of mistake? One, common mistake. So here, both parties are laboring under the same false assumption. So both make the same mistake. The second type is mutual mistake. Here, the parties misunderstand each other and are at cross purposes. So for example, A makes a proposal to B to buy B's BMW. B, in accepting that proposal, accept it with the understanding or with the mistaken assumption that A made a proposal for the purchase of his Benz. So here the parties are not at idiom. They are at cross purposes, or they are said to have mistakenly understood themselves. And by that, because there is no consensus, there is no contract. The third type is unilateral mistake. So under the unilateral mistake, only one of the parties is mistaken. The other knows or must be taken to know of his mistake. Quite often, this mistake is committed by the activities of rogue. So where they impersonate another person, and by reason of that, the rogue will obtain goods from a seller on credit. We will look at that in detail as we proceed. We will now consider the first type of mistake, which is common mistake. So under common mistake, two main groups of cases have arisen. One, cases where the mistake is over the existence of the subject matter. By subject matter, we mean whatever is being bargained for within the contract, the goods or services. And secondly, cases where the mistake is over the quality of the subject matter. Now, where the mistake is over the existence of the subject matter of the contract, the situation is known as res extincta. That is, the thing is destroyed. It means the contract is formed over something which is not available. So the mistake is so fundamental that the contract is held void. Cases such as Couturier and Hasty, Galloway and Galloway, and Scott and Coulson are illustrative of this point. I must say here that Section 9 of the Sale of Goods Act 1962 at 137 of Ghana codifies this common law principle, and I believe the title of the said section is Implied Conditions, that in any contract for supply of specific goods there is an implied condition that the goods are in existence. An extension of the principle of res extincta is that of res sua, which literally means the thing is his own. It arises in situations where the owner of a thing, unknowing to him or her, buys or purport to enter into a contract for the purchase of the thing he is already the owner. The second group of cases under the common mistake, as already mentioned, is mistake over the quality of the subject matter. The general principle is that where the mistake of the parties merely results in a bad bargain for one of them, the contract will not be void. This is consistent with the principle that the law only requires sufficiency of consideration, not the normal market value. This stresses the need for students of this lecture to have appreciable understanding of the basic requirements of a valid contract. For emphasis, any student who is wanting in this area of the law of contract must revisit the basics, i.e., offer and acceptance, consideration, intention to create a legal relation, and capacity. Back to the substantive issue. So generally, if the parties are already agreed on the same terms with respect to the same subject matter, the court are mostly reluctant to declare a contract void simply because the parties were mistaken as to the quality of the subject matter. A case which in fact is the leading case on this is Bell and Lever Brothers. Students are encouraged to also read the case of Leaf and International Galleries, and also Smith and Hughes, as well as Scriven and Handley, Hattock and Collin and Shields. I've already spoken about the mutual mistake, and I did indicate that in mutual mistake, the parties are not in agreement ab initio, because the parties misunderstand each other and are at cross purposes. A case in point is Raffles and Winchell House. Having discussed common and mutual mistake, I will now proceed to deal with mistake as to identity. This is an aspect of unilateral mistake, and in many cases has occurred when one person has posed as someone else in order to persuade a seller to part with goods and on credit. Mistake as to identity arises where one party has in mind a definite identifiable person with whom he intends to contract, but ends up contracting with someone else, usually through the fraud of that person. And the question is whether the court should enforce the resulting contract or declare it void on grounds of the mistake as to identity. We should recall at this point the rule in Bolton and Jones, which states that where a person makes an offer to a particular person, it can only be accepted by the person to whom the offer is addressed. Another person can therefore not accept the offer and constitute himself a contracting party with the offeror who never intended to contract with him. What then is the concern of the court here? The central question for the court to determine is whether the apparent contract concluded between the owner and the rogue is void on grounds of mistake as to identity, or merely voidable by reason of the fraudulent misrep of the rogue. The court, in resolving this issue, considers whether the mistake as to identity is established or not. If it is established that there was a mistake as to identity of the contracting party, the resulting contract is deemed void. The effect is that the rogue acquires no title or rights of ownership to the goods. This is consistent with the nemo dat rule. Consequently, third party who acquires the goods from the rogue does not or do not acquire any title. Also, if a mistake as to identity cannot be established, the resulting contract will not be deemed void, but merely voidable on grounds of the rogue's fraudulent impersonation or misrepresentation. So here the contract is one that is valid unless and until it is disaffirmed or avoided by the innocent party. Now, if a person alleges mistake as to identity of the contracting party, how does or do the court resolve this? First, the courts try to determine the status of the contract entered into between the owner and the rogue. The issue is whether the contract is void for mistake or voidable for fraudulent misrep. It all depends on whether the mistake as to identity of the contracting party can be established. What then are the guidelines for determining whether mistake as to identity can be established? Thankfully, Shisha, 5 Foot, and Firmstone had provided the answer in their book Law of Contract 13th edition, that the party pleading the mistake must prove that 1. He intended to deal with some person other than the person with whom he has apparently made the contract, and the latter was aware of his intention. 2. That at the time of entering into the contract, he regarded the identity of the other contracting party as a matter of crucial importance. 3. That he took reasonable steps to verify the identity of that party. The case of Candy and Lindsay will be helpful, so I encourage you to read that case. Now, the cases of unilateral mistake, which is mistake as to the identity of a contracting party, fall into 2 groups. They are contract 1, inter absentis, that is where the parties are not in each other's presence but deal at arm's length or deal via the post or via telephone. 2, inter prasentis, where the parties meet face to face. The cases of Candy and Lindsay, Phillips and Brooks, Ingram and Little, Lewis versus Avery are quite illustrative on this particular topic. The principle is that where parties are inter prasentis, they intend to deal with the person before them. So I will state that again. Where the parties are dealing with each other or in the presence of each other, the presumption is that the parties intend to deal with each other or to deal with the person before them, identified by sight, hearing, etc. And their contracts are therefore binding on that basis. The question is, can this presumption be rebutted, or is it a rebuttable presumption, or it is sacrosanct that anytime two contracting parties deal in the presence of each other, the law holds them stringently that they intend to deal with each other? So we'll look at whether it is sacrosanct or it can be displaced or rebuttable. So we have seen two forms of unilateral mistake. Thus, contracts inter absentis, that is, contract concluded via the post or in the absence of contracting parties, and contract inter praesentis, that is, in the presence of each other or face to face. The question here is whether the presumption under inter praesentis is sacrosanct or displaceable in certain circumstances. Indeed, it is displaceable or rebuttable where the rogue dishonestly claims that he is an agent for another person, a supposed principal. The presumption which applies in contract under praesentis will be deemed rebutted. In such a situation, there is no contract between the owner and the rogue, and the rogue, even though they transacted in each other's presence, the contract is supposed to be between the owner and the principal. Remember the agency maxim: he who acts by another acts by himself. So even if where the rogue poses as the agent of the principal, ordinarily it is deemed as the principal entering into a contract with the seller. But here it must be clear that the rogue does not have any authority from the principal, and so cannot purport to act on behalf of the principal. So even in that instance where the rogue purports or fraudulently purport to be acting on behalf of the principal, and on the basis of that enters into a contract and secures any benefit or goods, and subsequently disposes of that goods to a third party by the application of the nemo dat rule, the person who acquires any goods from the rogue does not acquire any good title. I hope that is clear. And so the seller can now claim the goods from that third party because the rogue did not in actual fact obtain any good title. A case that exhaustively discussed this particular rebuttable presumption is the case of Sugan Finance Limited and Hudson. Now, in summary, I would say we have looked at mistake. We've seen the effect of mistake under common law and under equity. Now, the courts where a person alleges mistake, a common mistake, the approach of the court is an objective one. But where a person alleges a unilateral mistake, it is a subjective one to be proved by the person who alleges that he labored under a unilateral mistake. Then we also looked at the types of mistake, which are common mistake, mutual mistake, and unilateral mistake. Then we considered the presumption under contracts inter praesantes and contracts inter absentes. Inter absentes, the parties deal with themselves via the post, but inter praesantes, it means they deal face to face. And under the face to face, the presumption is that where the parties deal in the presence of each other, the law deems that the parties intend to deal with themselves or between the person before them. Then we also considered the issue of a person acting as an agent of another, and on the basis of that secured any benefit. And the question is, in instances where that rogue subsequently disposes of the goods to a third party, does that third party acquire a good title? The answer is no, because applying the nemo dat quote non habet rule, the rogue does not have title and so cannot purport to give any title. The rule says that if you do not have a thing, you cannot give. So if you don't have something, you cannot give, and you cannot give a title better than what you have. It's on that ground that the third party does not acquire any title from the rogue, and the seller can reclaim his or her goods from the third party. The question I'll pose at this moment is, what is the relationship between a mistake and frustration? A mistake and frustration. This ends today's discussion.